I've just talked about shareholder agreements. You often find that some of these provisions are in articles of association. I'm really conflating the two together. You tend to find that if you get into larger companies, particularly with external investors, you're talking about private equity investors, they tend to want to pull these arrangements apart legally, and you often find there are a lot of provisions in the articles of association, particularly associated with transferring of shares, and good leaver and bad leaver. The difference is that the articles of association are filed at Companies House, so it's a public document. The other reason is a legal reason, is that if you do something contrary to the articles of association, it's ineffective. Whereas if you do something contrary to the shareholders agreement, you've got an argument with somebody, you're in breach, and you've got to enforce it. But if you're in breach of the articles, then it just doesn't happen. And you find that equity investors, whose business it is investing in companies, will pull things apart, as I say, and the articles of association become a much more important document than filed at Companies House. And the list of things that I've been talking about are sort of separated, and some of the management issues are dealt with in the shareholders agreement. But in essence, it's the same issues, just two documents rather than one. We tend to find that with smaller companies, when you've got 3, 4, 5 shareholders, it's not a huge benefit in having complicated articles. You tend to have simple articles and a very clear single document.